Welcome back. Hello, Mac.
Hello, good evening.
Sorry, it was taking a second to get off of mute. Hi, Chair.
Hi. Okay, we have a real good start here. So everybody, welcome to one more round of the enabling ordinance edit ad hoc. And we ended at 2.45.210 or 200, and we're going to start at 2.45.210. Authority of Public Ethics Commission. Now, why is this in here? If the commission does not receive the files and records requested pursuant to section 604 of the city charter. So it's about hearings. Okay, so it should be the sole and exclusive.
No, it's actually about holding accountable the people who are supposed to provide access to the
records.
So it's a remedy, basically.
So hearings, we start here on hearings, where it says it shall be the sole and exclusive responsibility of the commission to determine the order and conduct of any public hearing consistent with applicable law. And then here is some crossovers out, rather. If the commission does not receive the files and records requested pursuant to section 604 of the city charter or pursuant to this chapter 2.45 within 15 business days, then we have a certain remedy. We shall have the authority to investigate. Okay. So if we don't receive within 15 business days of its request, the Public Ethics Commission shall have the authority to investigate allegations that the head of the offending city department or agency failed to provide the requested files or records. And that's the only change, is that at first it had commissioner or inspector general. Now it has commission. So it's our ability to have the Public Ethics Commission investigate. Anybody have any questions about that?
I have a brief question, which is I'm wondering, and perhaps IG Phillips can speak to this, why this authority is removed for the IG, or whether it's incorporated in 2.47 at this juncture. Would just want to make sure that there remain enforcement mechanisms where possible. And then part two of the question would be whether the CPRA retains some enforcement mechanism beyond bringing this to the attention of the commission for any parties who are aware.
I can jump in, Chair, if you'd like.
Yes, please.
Thank you, Director Mira. So yes, what we did with these sections is there is a public ethics section under each chapter in this section. So 2.45 explicitly says commission, 2.46 says CPRA was the same language, and then 2.47 says the inspector general. So it removed it out of this section as 2.47 is the established section. And Mac, if you can tell me what was your second question? I'm sorry.
No, my second question you already addressed, which was ensuring that the CPRA had the same language, and that's my oversight, so I appreciate it.
Yes, no worries.
Okay, so shall we go on?
Miss Kathy's hand is up.
Yes, Kathy.
Good afternoon, everyone.
Hello.
I apologize for being a couple of minutes late. I thought we were picking up on commissioner training. That's what my notes show. 2.45.190.
Michael
No,
actually put a,
I
note.
put this here, yeah. This was here when we were all having the meeting, that this is where we were gonna start. Because we talked about training. Is that what you want to do again, or? But this is where we left off. We were going to start here,
Start where?
right here.
Oh, let me go to that screen because my,
Right here.
okay, I'm on my phone, so it's going to take me just a second. Okay, all righty. Yeah, for some reason I thought we weren't finished with that, but okay. Because I had a couple of questions about 190. Maybe we can come back to that later.
What did you have?
Looking at 5, 6, and 7, the city and state laws are kind of all mixed up together there. And so I thought it would be great if we could have, one devoted, like 5 could be devoted to just city codes. 6 could be 7, and 8 could be, or 6 could be state, and 7 could be a catch-all. Because there's a lot of going back and forth.
We did something with this. We made a new number 8, I think is what we did.
Well, we moved C down to the
Something
end.
we did with this. Yeah. Okay.
We did that, but then
Mm.
we didn't talk about, because this just occurred to me today with 5, 6, and 7. If all that, like, if you look at 5, it talks about California government code section. Then it talks about the Oakland's conflict of interest, and then it goes back to the California government code. And so if we could have like all the Oakland municipal codes in one section, all the state law in one section, or state codes, and whatever else, it's just a cleaner read to me.
I wonder why it's grouped this way in the first place then.
I think it is because like 5 starts out about saying receive training in the legal requirements of, and then that's been crossed out. And the 6 starts receive training in open session in the legal requirements. So I think that introductory language
Oh.
broke everything up. But now that language has been stricken, maybe we can do it in a way that flows a little better.
Well, actually, the distinction is still there as between what are those that are to be in open session. So
They're
all
all
of them,
crossed out though.
no. Look at the end of 6. Which training shall be provided by the city administrator or the designees from human resources and or employee relations, and shall occur in open session.
Okay. Oh, okay. And so 5, and so I see. And then the others, how would the others occur? Like behind, not,
Either we watch videos.
oh, okay. All righty. So it's not an open session.
Right.
All righty.
Ms. Rashida and then Mac.
Thank you.
Uh-huh.
Yeah, I actually was looking back at a previous section that I'm not sure how carefully we went through it. Maybe I'm just not remembering, but it's section 140, 2.45140, discipline. And I had some thoughts about the sections that refer to the Scully hearings, which are sections C and D and E. And the question I had, maybe Mac or Michelle could help me with, which is, it seems from what I read and which I sent you about Officer Tran, that the Scully hearing, the officer is represented by legal counsel. And I'm not clear on whether there's any legal counsel on the other side, namely the side that is seeking to impose discipline. So could somebody comment on whether that is an accurate statement and if we need to somehow address that here, or whether it might somehow impact the MOU? I'm just not clear on it. But when I sent that article out, Mary Vale had that comment that it seemed as though the officer had legal counsel present for the Skelly, and there was no mention of the city having legal counsel. Can somebody address that?
I certainly can't. I'm sorry.
So, go ahead, Matt.
No, please.
I have not observed a Skelly where CPRA is a party to the Skelly hearing. I have observed Skelly hearing where OCA has been present. But to answer your question, and I'll defer to Director Muir on this, is when CPRA is part of a discipline where they were, they had an investigation. I'm honestly unclear procedurally, just because in my tenure here, I have not seen a case go to Skelly and CPRA was present.
Yeah, and I thought, Mac, I thought that was one of the reasons why we added a second legal counsel to CIPRA, so that CIPRA could, in fact, be involved in the appeal process.
Yeah, absolutely. So what I will say is, since our legal counsel position was filled 2 months ago, we have not had a Skelly. We've had outside counsel for what I understand to be 5 or so years. And that more broadly, as it relates to Section C here, the representation and who represents whom in this hearing, I don't think can be dictated by this ordinance. I will say that the city is the party that it seeks to impose discipline, is my understanding. Even it's that it is the city representing itself as an employer to the employee, and that is the dynamic, as opposed to an individual agency and an employee of another agency. So my understanding is that CPRA can take a lead in that role, but in the imposition of, or in the arguments that take place there. But I think that's to be determined with the in-house counsel as part of the process. I don't think that this is the section where that needs to be addressed. And if you're concerned that an officer has a legal counsel, but that the city does not, I don't believe that to be the case. And I think that representation is not an issue that's been flagged to me before in a way that would certainly draw concern if I had heard the same.
Okay, I appreciate that. I'm not sure that I'm satisfied, especially given the number of reversals of discipline that have occurred, and the history of the city bringing in outside counsel who's not necessarily well versed in the investigative process. So it's something that I want to flag, and if you don't think it's appropriate in this ordinance, then I'm not sure where it would be or how it would be addressed. But it is a concern that I
I
have.
don't think it's any problem, at least flagging it and getting that question answered, since we were informed that other stakeholders have drafted this and have obviously made their changes or concerns known. So thank you, Mr. Sheedy.
Would you please mind just rephrasing or saying what the actual question is? There's a lot of dialogue about it. I want to make sure that I'm capturing your question or what you're actually flagging, please.
Well, my question would be whether CIPRA counsel should be included in the Skelly hearing.
Okay,
Thank you.
you're welcome.
So can I jump in really quickly? Because I just would like some clarification on that. The CPRA council representing the city in some form or fashion, or representing CPRA, or CPRA council as an observer?
I would think not just as an observer, I would think as a participant.
Okay, Matt.
Apologies for interjecting. I would just say that I think some of the issues you're flagging perhaps relate more to collective bargaining in the disciplinary process in a general sense, or who the Skelly officers are, or who arbitrators are. But as an agency that seeks to promote accountability, I would, as the director, I would like the discretion as to whose advice is being sought or who's representing the agency in a given instance. And that my understanding again is that we can have a representative of an agency, but it is the city, and the city attorney is the attorney for the city in a disciplinary proceeding as it presently stands. And that I don't know that we could necessarily expand that without running into a series of other bureaucratic hurdles.
I'll jump in. That's my understanding as well, Director Mira, that it is the city attorney's office who will represent the city as a whole. And CPRA is an agency within the city. Attorney's office, not administrator's office.
Thank you.
You're welcome.
Michelle, you broke up just a little bit. So I got city administrator, actually, city attorney's office. What? Because you broke up a little bit.
No, I was just saying you're correct. The city attorney's office, and I saw you backspacing, so I thought you heard me.
Okay. No, the rest of what you were saying, because you were agreeing with Mac.
Oh, yeah. So what I was saying is that essentially Mac is correct in that the city attorney's office is in that position, specifically when it comes to Skelly, to, from my understanding, represent the entire city of Oakland in those disciplinary matters, which is inclusive of CPRA and their recommendations.
Yeah. Okay.
Yeah.
Okay. Cool. Thank you. Duly noted, Miss Grenache.
Thank you.
Back to Ms. Leonard, though. Kathy, did we respond fully to your question about the training?
Yes.
Okay.
Yeah.
Can you put your hand down?
Oh, you know what? It looks like from my screen that it's down, but I will press it again. Thank you.
No, your hand is going to be perpetually up because it didn't go down. Okay, so we're moving on to 2.45220. Administrative hearing upon removal of chief. This is new. Yeah. Upon removal of the chief from office for any reason by any authority within the city, the chief shall be entitled to an administrative appeal in accordance with California Government Code, Section 3304C. Removal for the purposes of this section shall include any action that constitutes removal under the code, including but not limited to termination. The chief shall have 10 calendar days from service of the notice of the action constituting removal to request an administrative appeal. The request for appeal, it says much, but it should say must be in writing and must be directed to, at a minimum, the commission, the mayor, and the city attorney. The administrative appeal procedure shall be as follows. The city will retain an independent hearing officer, the cost of which shall be borne by the city. The hearing officer's assessment, your comment box is right in the middle of what I was reading.
There you go, sorry.
The hearing officer's assessment of the removal and findings of fact. Where am I? And findings of fact related to the same shall serve as a non-binding recommendation to the city. The hearing officer shall receive evidence solely through records, sworn declarations, and argument. The parties' arguments shall be oral, except that either party may also elect to submit a closing brief following the presentation of evidence. Any evidence introduced in a closing brief, not previously introduced or submitted to the arbitrator, will not be considered. Closing briefs shall be submitted within 20, but then they have 30. Do you see that? 20, but in print they have 30 calendar days of the close of hearing.
Right here.
Yeah. You might as well, I don't know if they mean 20 or 30.
Okay, we'll put a note.
Well, yellow, the whole 20 and the print
20.
30.
Okay, does this mean 20 or 30 days?
Yeah.
Then 20 be 30.
Whatever. Something happened there. You might want to highlight that.
Where to go? Where to go? Right here.
Yeah. So many days of the closing of the hearing. The hearing officer will not consider briefs submitted after the deadline. The hearing officer will finalize the evidentiary record and submit a written report, rendering a non-binding recommendation to the city, and as necessary to make recommendations, make underlying findings of fact about the removal of the chief, whether or not the removal decision was supported by just cause. So far, so good. Hearing nothing. The hearing officer.
Yes,
Oh, I'm sorry, Kathy.
I have a point. So in the second paragraph, the chief shall have 10 calendar days. Just for uniformity, after the word 10, we should include a parentheses, the number 10, and close parentheses.
You have to scroll up.
Thank you. Where was that, Chief? Am I close to it?
It's the second full paragraph. The chief shall have 10 calendar days.
Yes, right here. So right here.
Right.
Is what you're
And then
saying.
the second one is in the the fourth paragraph, the second line up from the
Fourth
bottom.
paragraph. Second line up here.
From the bottom. After
From the bottom.
recommendation, should we include the word and?
A non-binding recommendation right here.
No.
A non-binding recommendation to the city and is necessary to make such recommendation,
No,
and then
not-
include the word and, make underlying findings of fact.
Oh. And I think after chief, don't they make, is that a period or is that it should be a comma?
Yes, a comma. Thank you.
Mhm. Wait, is that right? Period. Should be a comma. Period. Bear with me one sec. Period. Should be a comma. Do that. And then I want to do like this. I want to do a comma. something like that.
Yeah, in a space. Yeah,
Okay.
whether or not, okay, and so is there anything else there? If not, let's see, the hearing officer shall submit the report within 30 calendar days of the close of the hearing, unless either party timely submits a closing brief, in which case the record shall be finalized and the complete record shall be delivered within 60 calendar days after the close of the hearing. The hearing officer shall provide the following materials to the removing authorities. I wonder, is there a definition of removing authorities? For their consideration, which shall constitute the official hearing record. 1A, a summation page delineating the name of the hearing. Any and all issues set forth by the parties during the administrative appeal hearing, a brief summary of the written report. 2, the complete written, and in your box is it right in the middle of that. I can't read anymore, Micah. Your box, yeah. 2, the complete written report rendering all findings and recommendations. 3, any documentary evidence and any written brief submitted. And 4, the cassette tapes of the hearing. Is there such a thing as a cassette tape these days? Has anybody been in a hearing where a cassette tape is the record?
Matt raised his hand.
I hope not. I do have one other note here. It's actually at the top of the page, at the very top line. Now it is in the central paragraph here. The city will retain an independent hearing officer. On the 4th line in the center, it says any evidence introduced in a closing brief not previously introduced or submitted to the arbitrator will not be considered. That should say hearing officer, not arbitrator.
Mac, is my cursor near anywhere what you're talking
You're right
about?
there. You're
Right here, right here.
arbitrator should say hearing officer so as to not confuse that.
Okay.
And cassette tapes, perhaps we could go with audio recordings instead.
Are those hearings videotaped as well, or is just an audio recording?
Sorry, which?
Under where we're talking about the cassette tapes.
And I think they have hearing officers sometime initial cap, like down here. We should just be consistent.
Where? Okay, lead me to the cassette from where I am
Okay,
right
so
here.
It's in the same paragraph where it starts, the hearing officer shall provide the following materials. And hearing officer is initial caps. No, go down. Yeah, it's in there. The last sentence there.
Oh, cassette. Here. Are we doing hearing officer first or cassette? Where are you leading me?
It doesn't matter because it's up.
Okay.
The initial caps for the hearing officer is up in the next paragraph above, but we're now
Right here.
dealing
Got it. Okay.
with cassette tapes.
Because you said audio tapes, right, Matt? Oops.
Well,
Audio recordings. Audio recordings.
audio or video. I don't know, digital recordings. I don't know.
yeah, that was my question. Are they do they videotape those hearings as well? And if so, then we should include that in this section. That the hearing is as something that the hearing officer should provide to the removing authorities.
Understood. My understanding of this section is it is creating its own new disciplinary process for
Yes, for
the chief. So there is no precedence as to how that hearing would be documented. I am not aware of there currently being audio recordings of disciplinary hearings, although I may be mistaken, as I have not participated in arbitration or SCALI at this juncture.
Well, let's flag that and check that out. You know, it's always good to have a video recording to check the demeanor of people who are giving testimony.
So
Okay,
did I get that right? Audio or video recording?
Correct.
Okay.
well, we
Thank you.
could say and/or.
Okay.
And just to be consistent, like we said, going up to the paragraph before, hearing officer is initial cap. No, down to the paragraph, that
Ah,
one.
I see.
And one other place. You know, up
Yeah.
here-
Let's
up
see.
here it says, the city will retain an independent hearing officer. I guess it's,
It's a
Initial.
lot of it in
It's
that
a lot.
paragraph.
Yeah, right
Hearing.
there.
Okay.
Probably do a search for that.
Yeah, my only fear is that that appears someplace else in the entire document and could take us someplace else. So
And
I
then
don't-
that's,
Well, we could just make a note and do it later.
and we'll keep going down that line in the next sentence.
right here.
It's all over, and then above that as well.
Okay.
I don't want us to spend too much time on this kind of editing though.
So how about we make a
Up here
note, please make sure hearing officer,
is initial caps.
hearing officer has is written with cap.
Then in the next sentence,
Initial
after
caps.
there's a discussion about the cassette tapes, the hearing shall be audio recorded by the city. Copies shall be provided to the appellant for no charge. Should we also put the hearing? Well, we don't know if it's video recording. The hearing shall be audio recorded and or video recorded.
Well, we don't know. This is new.
I
but
know
certainly
right, but
not
we're making
cassette
but
tape.
we're making allowance up above. So should we make that same allowance here?
Sure.
Okay.
So we've got this. You want to point me, please?
Um,
So we talked
below
about
the
this.
the next paragraph below cassette tapes. I
Uh-huh.
can't see it because I'm on my phone.
Oh, I see. It
Yeah,
says-
because if I switch, yeah, and it says the hearing shall be audio recorded by the city,
uh-huh.
audio recorded and or video recorded. And then the final sentence can stand. Copies of the recording will be available to the appellant because that will
Capture.
include audio or video. Thank you.
Mm-hmm.
And there it's hearing officer again. The hearing officer's report and all of the related accompanying documents and materials shall remain confidential to the extent required by the law. This is interesting. So would this also apply this is only if the commission removes the chief for cause, or is this does this also pertain to an at-will firing by the mayor?
So that is my question. I'm not, there's no reference to the commission here at all. And
Yeah.
I'm wondering why this was inserted. It's
Yeah.
entirely new, and I don't
Yeah.
know why it belongs in this ordinance. Can somebody help me understand that?
So I will say I didn't have anything to do with this crafting, but this was entrance by, I want to say, the city attorney's office regarding this process. So that may be a question, Micah, maybe if you like, or Chief of Staff Montgomery, my apologies, a note for the commission to maybe ask specifically once they get meetings with stakeholders regarding the insertion of this section.
Uh-huh.
And it may be best suited elsewhere.
This whole section.
Yeah, it's
Yes.
all
So if you want to
Let me put it on the top.
at the header,
here.
yep. Yeah, absolutely.
Okay.
Yes, ma'am.
Should this section be moved did you have a recommendation like where it should be moved to?
No,
Another
why is it, is this a hearing if the commission removes the chief, or, and why, otherwise, why is it here?
It's
So
relative to the commission.
I would assume that this is guidance for the commission because this ordinance section chapter speaks
Is for the
specifically to
commission.
the commission.
Right.
Correct. And there is a built-in process after the removal that the chief has, that I believe the former chief did go through.
Yeah,
Once
the independent review by that jurist.
and that's I think that's that's in the law.
Right. I understood that one, but, so this is a we're the removal authority then. I was asking for a glossary term, what did they mean by removal authority? So I guess if it's here,
It
we
would be
are
the
meant to
commission.
be the removal authority.
Which would be the mayor of the commission, correct?
Well, if it's
For
here,
the
it sounds
purposes
like
here, it would be the commission. I'm
it would be
sorry,
the commission,
Chair.
yes.
There would be something else that would govern the mayor and her authority, or whomever sits in that seat, their authority at that time. But given the fact that the mayor has the ability to remove with or without cause, a hearing would not necessarily on the front end be necessary.
Right, so in other words, if the commission should remove him for cause, he now has this appeal process. Is that,
I see Director Muir's hands up, Chair.
yes. Matt?
I will note, it says upon removal of the chief from office for any reason by any authority within the city. I guess this assumes that if the mayor were to relieve the chief of their duties, it would be without cause and for no reason. But as I read it, this could apply to the mayor. And I just want to flag that for consideration, or that there be some legal opinion on whether or not that's the case, as this is recommended to council as.
Well, again, when we need a definition of who is the removal authority as it pertains to this.
I'm sorry, Michael, when you're finished, can you remove the box so I can read this in its entirety? I'm not
Is that better?
lazy. Yes, ma'am. So I can
Okay.
actually read it. That was
Got it.
more so listening.
Sure. So we need so you were saying you need a definition.
Why
of
don't
whether
you put your box above 2.2452? Yeah, there.
Okay, I'm gonna roll what I said back. This explicitly cites section 3304C of the California Government Code. So to Mac's point, and Mac, I appreciate you flagging that. I definitely was being lazy and not reading it. That this hearing process is based on what is written, and the appeal process that is granted in the California Government Code 3304C for that particular reason in these first couple of sentences. So I would assume that any of this language is probably derived from that code. But if they're just using this section to cite the code to say the administrative hearing upon removal of the chief is already granted by 3304C, then I don't really think there's too much more. Now, there could be clarity in how this is written, but procedurally, to Mac's point, is that this would be after the removal, as I'm reading this, and what was initiated by the chief earlier,
But
or the former chief, excuse me.
yeah, but the removal authority is who? When they're speaking in this section, are they speaking of the commission being the removal authority, or anybody but the mayor or us?
So-
My,
Go ahead, Mac, please.
Thank you. My reading is that it's by any authority within the city, which implied is including but not limited to the police commission and the mayor. I will just for our reference read from 3304C, which says no chief of police may be removed by a public agency or appointing authority without providing the chief of police with written notice and the reason or reasons therefore and an opportunity for administrative appeal.
But that would be a for cause, and the mayor could do it without cause. We're the ones that have to do it for cause.
Well, no, they still have to be noticed. Chair,
Well, of course, yes, they have to be noticed, but that other part that says, and reason therefore, that's a for cause.
Mac, can you reread that section again?
Yeah, it's longer than what I just read, and part of this, I'll read the full language. No chief of police may be removed by a public agency or appointing authority without providing the chief of police with written notice and the reason or reasons therefore and an opportunity for administrative appeal. For purposes of this subdivision, the removal of a chief of police by a public agency or appointing authority for the purposes of implementing the goals or policies or both of the public agency or appointing authority for reasons including, but not limited to, incompatibility of management styles or as a result of a change in administration shall be sufficient to constitute reason or reasons. Nothing in this subdivision shall be construed to create a property interest where one does not exist by rule or law in the job of chief of police. Now I'm editorializing, the property interest is whether or not the person's at will in sum and substance, not speaking as a lawyer, but that's my understanding.
Well,
So
that's what gives you that right to appeal is you have a property interest in the job. And isn't that the Skelly decision?
no, it would be
That other decision,
this,
that
sec-
there's two cases there.
that would be this section. So Skelly is a subdivision of sort of the labor rights as a representative public employee, and that separately, this is really applying to just chiefs of police, that there should be an administrative appeal process. To what end, I would seek guidance on, and because I don't know if this administrative hearing officer says that the chief shouldn't be removed, I don't know what that means. And perhaps I haven't, that's built into the text here, but it's not clear to me.
It was a particular case that I'm thinking of. Anyway. So again, where is that reference to the removal authority? Can you scroll down a little bit more? Yeah, the hearing officer shall provide the following materials to the removing authorities. Can we get a definition of removing authorities? Do you see where I am? The first sentence of that line right there. So they put an appeal right that could also include removal by the mayor in this section of this enabling ordinance dealing with the commission. Is that what you guys are telling us? Mac?
I think it would merit asking because it depends on the property interest clause here, and perhaps Twee can speak to that. I don't know where the property interest would intersect with this. My reading now, as I look at 3304C, is that this is just an attempt to ensure that that provision of POBR is included in the ordinance. But as you can see, it's a non-binding recommendation. So it allows for the chief to have a hearing that may or may not have any impact on the decision, but still ensures that they have a form of due process.
Okay, well, again, I don't dispute that there has to be notice, but I am questioning whether or not when it is done by the mayor, it doesn't require the mayor to set the reasons why. It's like, thank you, your services are no longer needed.
So what I will say is, and Commission Council had put in the chat, if nobody saw that particular section, which is appreciated, where it says that the reasons can be, but are not limited to, incompatibility of management styles, and Director Mayor wrote this, or as a result of a change in administration, right? So shall be
Right.
sufficient to constitute reasons of reason or reasons.
And then what is she, if we scroll down, what is it? Nothing in this subdivision shall be construed to create a property interest where one does not exist by law in the job of chief police. And that's, again, if the mayor does it for no cause, he doesn't have a property right in an appeal of this nature. But this is creating an appealable right, it seems. By whatever removing authorities. And that's my concern. Who are these? Who are the removing authorities that they are referencing?
It would be both the commission and the mayor for the city of Oakland.
But I don't think that this enabling ordinance should create a right in the chief that doesn't exist for at-will employment removals like the mayor is entitled to.
So I think this is an FYI because the law says it in 3304, and the city of Oakland must abide by the state law. So I think this is for reference for the commission in this particular section, that, you know, as one of the authorities, removing authorities, commission 3304 governs acts. But it would also govern the mayor as well. But this is just an FYI to the commission for this particular section.
Well, then Michelle, would Chief Armstrong have had a right under 3304C to appeal his termination by the mayor?
From what I understand, that was the external.
That was that right. He exercised that, but that is to that independent jurist. This seems to be a right established under the commission's rules.
I'll go ahead and defer. I am reading this differently, so it may be best to have legal counsel to opine on this.
Okay. Well, we've raised the question right in the box. Micah?
Yep,
Yeah.
Peter Fish, all right?
And this section is reference for the commission. Yeah, I'm just, we need some clarity. Anybody else have anything else to say about this section? Now, this is the next session, 2.46. Didn't we already go through CIPRA?
Yes, we did.
Okay, all right. So then the only thing we need to take up now is the IG 2.47, is that it? The new section. Yeah. Okay. Well, we can kind of speed through this one because I think there's not a lot of wordsmithing that should go on here. I've pretty much, Jesse and I had side meetings with the IG, and I think we pretty much have others on the Zoom have an opportunity to look over this section 2.47. And if not, we can go through it line per line, unless you can point to some sections that you want to raise questions about.
I just remember, and I have a note here, and I'm not sure, maybe the IG raised this, that we should review measure S1 to make sure that there's no conflicts with this section.
Excellent idea.
Well, okay, we can do that two ways. We've been on this Zoom for about 45 minutes. We can switch over to S1 and look at it, or we can pledge to look at S1 and look at 2.47, and next Monday when we meet, only raise issues where we feel we need to make comment. I do not have S1 in front of me. I don't know, how do you want to approach that?
IG, this is your section. Should we, do you have any input on this?
So I've gone through this section, and I've gone through this section as well with the commissioners, Chair Peterson and former Commissioner Shea. And I didn't see any conflicts with S1, and with Chair Peterson, her and I on several occasions had S1 up and kind of went back and forth on this, and we didn't see anything. Of course, extra set of eyes are okay, but I didn't have any issues, and any questions that Chair Peterson or Commissioner Shea had, I was able to answer. So if anybody has any specific questions about this, I would be happy to answer as much as possible, and provide context.
I don't have any questions, and I'm satisfied if the IG has gone through it and gone through measure S1 and this section and finds no conflicts. Thank you.
Yes, ma'am. I think it might be helpful for us to at least kind of go through it, Chief of Staff Montgomery, if that's okay with Chair Peterson. And
Yes.
if we can get through it, given the fact that we still do have an hour, we may be able to conclude this during this meeting, and then the commission compile notes with your council and how you all want to proceed and move forward with other stakeholders.
Okay, well then let's back up. There's a glossary of terms here, words, OIG, and all of that. I think we may be okay with that. We have 2 dots after Oakland Police Commission. That's minor, but I guess we're wordsmithing, and we are up, 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 up. See where it says commission shall mean the Oakland Police Commission. Oh, maybe, anyway, let's keep going. I don't see the extra dot. I think that was just something on my own screen. I'm so sorry, guys. Civil service employees, C, the inspector general shall be subject to a background check. D, any reports, plans, audits, reviews, and recommendations generated by OIG shall not disclose information in violation of state and local laws. Let's see, functions and duties. In addition to the powers and duties prescribed in section 604 of the Oakland City Charter. The OIG's functions and duties are as follows. Conducting any audits and any auditor reviews, department, preparing biennial report, the department's process for investigating alleged misconduct, preparing, okay, this is all the things that need to be in the annual report. Can you take a minute to look at and see if there's anything else? Are you satisfied? Let's see, conducting any audit review of the department necessary to assess the department's performance and adherence constitutes policing practices. Any audit review of the department's policies and procedures, including any pattern of non-compliance with foregoing, is necessary help for the commission to fulfill its duties. Preparing a biennial report summarizing the results of the biennial reviews of, and then there's this list of 7.
So if I may, Chair Peterson, I'd just like to note for the ad hoc that these are the items that are required to be in the biannual, the biannual report. Of course, it is contingent upon resources and availability, but this is the floor, not the ceiling. So the Inspector General will probably provide more information and more context, but these are required in the documents. I just want to let folks know this isn't all that should be in the document, in my opinion, as the current Inspector General, but additional information should be in there as well. But these 1 through 7 are required.
So should we state preparing a biennial report summarizing the results of the biennial reviews of at least the following, but not limited to, or something?
I think that's implied.
Oh, you think? Okay.
Absolutely. Because I just don't, any good, and I hate to say it like that, but any good agency director is not just going to throw 7 pages together without context and guiding the readers through.
But remember, you won't always be maybe that person.
Correct. But given the fact that there are certain requirements for this position that govern how inspectors generals do what they do, that would just not be acceptable, period, for any inspector general in this workspace. And it doesn't preclude, this section does not preclude the commission from asking for certain other information to be in the annual report by way of vote.
So if we were to put preparing a biannual report, shall include but not limited to summarizing the results of the, I don't know. I don't, you drafted this?
I didn't draft it, but I don't think it's necessary, because if we look at the information for the previous ordinance, it essentially says the same thing, except for it's an annual report versus biannual report. It's a copy paste job.
All right. Anybody else have a comment on this? Okay, let's move on to 7. See, oh, this. What is this? What number is this? Where does
This
this?
is after your 7. So you talked about the 7, and then this came
Okay,
right
and
after.
so that's the concluding part of this,
Mhm.
of that section.
Yeah.
Okay, and so the next is C,
Mhm.
monitoring and evaluating on at least an annual basis the number and percentage of officers who have received in-service training on profiling and implicit bias, procedural justice, de-escalation, diplomacy, situational problem solving, and work-related stress management, and make recommendations as appropriate to the commission regarding changes to the department's training programs. Let's see, D, developing and presenting a plan to the commission to measure the performance of each element of the department's discipline process for officers. F, monitoring, evaluating, and making recommendations regarding the department's recruitment and hiring practices for officers. G, monitoring, evaluating, and making recommendations regarding the department's policies and procedures as requested by the commission in furtherance of its duties under City Charter Section 604B4, 5, and 6. H.
I have a comment on this one.
Okay,
Okay, I think that we may have discussed this section because I have a note here that says, in addition to G, proposing, approving, or rejecting departments' proposals and all other policies. And I don't remember how that fits in, but I have this note there.
Well, if we're talking about the department, that wouldn't have anything to do with this particular section, because this is the section for the IG's recommendations. So if we're talking about things coming, the recommendations for policy reviews or revisions, excuse me, from the department to the commission, that would be something that need to be in the commission section. If that makes sense. Ms. Catherine?
Okay, yeah, that does make sense. Yeah, I just had this note here and I wasn't sure how it originated, but thank you for that clarification.
Yes, ma'am.
and so the last one, H, monitoring, evaluating, and making recommendations regarding the department's risk management practices.
Mhm.
So, any comments on those sections? Hearing none, let's go to 2.47.040, civilian inspection.
Actually, sorry, I actually do have a comment on the risk management. I'm wondering if, as an accompanying idea, that we're also looking at the issue of the reversals of discipline, because the whole idea of risk management is to essentially try to analyze the causes of risk, namely the negative impacts of policing, and minimize those. And to the extent that disciplinary actions get reversed, is the extent to which risk is not being managed. So I don't know if I'd be curious to hear IG Phillips' thoughts about that. Thank you.
I think that's an interesting way to assess and I guess conceptualize risk. I didn't think of it that way. When I think of the reversals or the discipline process, I think of it as it relates to task 5. Not necessarily risk management in that way, because when I it's nothing wrong with it, and I think that that's a really interesting portion, and it can fit. So I'll say that I think that that could be a portion of the evaluation of the risk management practices, but on the outskirts. I just think it fits a little bit better in the disciplinary process. That was up a little higher, and then maybe the results of the disciplinary processes. So if we are evaluating the disciplinary process, that also means outcomes at every step of the disciplinary process. Where am I looking?
Yeah, that makes sense. I think that's a great idea.
No, I appreciate you bringing that up and talking that through. And does that make sense to the rest of the ad hoc? Thank you, Ms. Rashid.
I think
Sure.
so.
It makes sense to me.
Me too.
I'm
Great.
good. Okay. And then the next section is Inspector General's job responsibilities shall include, but not be limited to, the following. A, managing all OIG audits, evaluations, inspections, and reviews. Subject to Charter Section 604 F5, the Inspector General shall have sole discretion in deciding whether and how to conduct any OIG audit, evaluation, inspection, or review, including decisions regarding timing, methodology, findings, recommendations, and reporting. In considering requests for audits, evaluations, inspections, or reviews, including requests from the mayor, city administrator, or city council, the Inspector General shall take into consideration the OIG's priorities, resources, and available funding. B, completing the training described in City Charter Section 614C9 and in Section 2.45190 A through F of this chapter 2.45 within 90 days of taking office. What is the training under this chapter 2.45?
That outlines the same training that's required by the commission. So I'm not dying on that hill to write it all in this section if we have a reference, as this section references several sections in charter and municipal code.
Okay, so this is cross-referencing some city charter and some chapter in chapter 2.45 of the type of training you have to take within 90 days of taking office.
Yes, ma'am.
And just for my edification, have you done that?
Yes, ma'am.
I'm sure you did. Thank you so much.
No worries at all, of course.
C, overseeing the day-to-day operations of the OIG, including but not limited to the supervision and direction of all OIG staff, subject to any duty to meet and confer with an affected union. The Inspector General shall have sole should have sole discretion in setting the operating procedures for the OIG. Any comments on any of that I've read so far? Okay. Reporting quarterly to the police commission at a
I'm sorry, Chair Peterson. What I will say is that I know other commissioners had questions about this particular issue, not issue, but this particular verbiage in here. One thing I will say, past practice, and I think this is something that I had written in the iteration of the new SOPs, is that all of our standard operating procedures for the office are public facing. And once there are new iterations to the SOPs, they will also be in the agenda packet for any comments by the community. I think the challenge with kind of crafting SOPs specifically for the OIG is that it's such a technical and niche type of, like, auditing is really niche. When it comes to kind of technicalities and what governs it, we have very clear guidelines. We have the yellow book, which is government auditing standards, that outlines how we have to do audits, and then there's the green book, which is the Inspectors General guiding principles. So it's not too much to deviate from that, and I think that that's one reason why this section, that is one reason why this section is written the way that it is, and those guiding principles and the auditing standards are notated in our standard operating procedures as well. And that's just for members of the public that may be listening.
Very good. Okay, so we're on, thank you for that, IG. We're on D, reporting quarterly to the police commission at a public meeting on recently completed, pending, and upcoming audits, evaluations, inspections, or reviews. The Inspector General may, upon mutual agreement, between the Inspector General and the Police Commission report more frequently. So up until recently, I think the Inspector General was scheduled to report every other meeting, and then now it's every other month, and this standardizes it as quarterly.
So I'll correct Chair. Since August of 2022, it has always been every other month because the Inspector General, when I came, was doing the first meetings of the month, and then the CPRA was doing the second meetings of the month, understanding that the OIG doesn't collect data as quickly as the CPRA, meaning the CPRA could get 20, 30, 50, 100 complaints a week. I might be exaggerating, of course. Whereas though an audit, we don't move as quickly. It's just a longer time. So taking time to put in information just to come and say, we're still working on this audit, we're still finishing up this, it just doesn't serve a purpose, in my opinion. And it's just not helpful. We can be working while I'm working on crafting those reports for the commission. We all could be working on the actual substantive work. And given the fact that we have very limited resources and may have even more limited resources, given our budgetary challenges that we're facing right now, I'm big on making sure that we utilize our time effectively and efficiently.
Okay.
Miss Kathy, your hand is up.
I think that's a legacy hand. Hey, Kathy. Are you on mute? Mute, Kathy.
Okay, I'll take it down. Thank you. This working on the phone is just so hard because you have to shift through a screen that tells you can talk, a screen where you can see what's going on, another screen for raising and lowering your hand. So it kind of takes a minute.
Well,
Sorry about.
it's just 5 or 6 of us. Just break in when you need to. Okay. So we are on E, and that part about agreeing to report more frequently on a mutually agreed upon basis, I think is the catch-all if we need to hear from the IG in between these quarterly reports. So let's say I'm fine with that. So E, observing or having a designee observe executive force review boards, and to the extent permitted by law, Skelly hearings. Attendance at such events by the OIG shall be at the Inspector General's discretion. The Inspector General shall not have any decision-making authority regarding the specific cases being heard and shall maintain the confidentiality of the hearings as required by law. The Inspector General shall not be permitted to attend any executive force review board, or Skelly hearing until they have completed the training identified in section 2.45190C. The Inspector General. Okay. All right. For certain training. Does this also allow you to attend this or observe? Is there anywhere where it allows you to observe disciplinary
committees? So you and I, Chair Peterson, had this conversation. It doesn't explicitly say it, and I think that it should, given legal guidance that has been provided to the commission, particularly because there's a requirement for the Inspector General to review the disciplinary process and evaluate the disciplinary process. Discipline committees are a part of the disciplinary process. So if the OIG is not able to observe that portion of the process, there cannot be an effective and quite frankly, efficient review of the disciplinary process, given the fact that we would be precluded from one portion of it. So that evaluation would not be complete. Given the fact that there has been concerns from legal counsel regarding the OIG's attendance, I think that where it says applicable law regarding the Skelly, because there are certain laws regarding outside folks, and I say outside folks with quotations, seeing hearings. So if the IG's office is eligible to review or to observe Skelly hearings, and we have unfettered access to all of the documents, I think it would just be helpful for discipline committee or Skelly hearings and discipline committee hearings.
Okay, so then we should insert observing or having a designee observe executive force review boards,
And to the extent by
and
law,
it's by law,
Skelly hearings
Skelly
and
hearings.
discipline committees.
Yes. So that should be inserted after Skelly hearings.
The
That first
Chief
sentence,
of Staff Montgomery, and we can go up
Yeah.
to the first, yep, the first sentence as Chair Peterson stated, right? Yep, that one all the way at the end.
where it says Skelly hearing is where you, at the end of this sentence, it says
Here.
Skelly hearings.
Here,
No.
No,
First sentence after
the
each.
first sentence.
yes,
Mhm.
here,
Go all the way to the end, Skelly
ma'am.
hearings. And so what you want to put comma and disciplinary committee meetings.
So I would just say
I would-
discipline committees because that's what we call it and everything else. Discipline committee.
Discipline committee, and
Yes,
it
ma'am.
should be initial cap.
Mhm. Thank you,
say that
Chair.
one more time, and discipline,
Initial
Committee.
cap, D, capital D,
okay, committee,
and it's committee, yeah.
okay. This is that. Okay,
I have a comment when you're ready.
Sure.
The reference at the end of section D to section 2.45.190C, we relettered that section. And so we should check to make sure that it's that we're referring to the right section in 190.
okay, so you said D, which one did you say, Miss Kathy?
D, at the end of D, it refers to section 2.45.190C.
Oh,
No,
B,
not
B as in
Bravo.
boy,
Mhm.
No, C as in Kathy.
No, it
Doesn't
isn't.
it say? Oh, I must have the wrong document then. Okay.
No, no, please don't say that.
All right. Okay. I just want to make sure that that had been relettered. So I guess it has been then.
okay,
Okay. Thank you.
uh-huh,
Okay, after preparing a proposed budget for the OIG, the proposed budget shall be delivered to the commission by February 1 of each year. In addition to submitting the OIG's proposed budget to the commission, the Inspector General may submit the proposed budget directly to the mayor and the city administrator by the earlier of April 1 of each year or such other date as set by the mayor.
Chairperson,
Yes.
I want to go back for a second. I think that
Okay.
the end of the section that we just discussed about adding the discipline committee, it needs to be reiterated at the end of that section that talks about preserving the confidentiality. And it lists the Skelly hearing and so on. It has to also include the discipline committee at the end of that
Oh, I see
section.
what you're saying. Permitted to attend any executive force review board, take out or,
Right.
and then Skelly hearing. Or,
And
well, there's an or. Why was the or there? Inspector General should not be permitted to attend any executive force review board, or Skelly hearing or disciplinary until they have completed the training. So,
Right, but it needs to include
Or-
discipline committee.
yeah, discipline committee.
Right, sorry.
Very good. Well, it's nothing like several eyes. Ah, so we were on the budget. I read the first couple of sentences and I was at, okay, in addition to submitting the OIG's proposed budget to the commission, that's in addition, the inspector general may submit the proposed budget directly to the mayor and the city administrator by the earlier of April 1 of each year, or such as a date as set by the mayor, consistent with the inspector general's authority to organize and reorganize the OIG and their designation as a department head under Charter Section 604E6. The commission may not direct or require the transfer, deletion, or other alteration of funds and staff positions that the city council ultimately budgets to OIG. Hands off, huh? Okay. Any comments on that? I think once the budget has been approved by the city council, the OIG's budget, the commission cannot interfere. Sounds reasonable to me. Anybody have any comments? Then let's go on. 2.47.060, Authority of Public Ethics Commission.
050, Chair.
060.
No, you skipped 050.
I'm so sorry. Background checks. 2.47.050, background checks. In accordance with federal and state law and consistent with Section 604E7 of the city charter, background checks shall be performed on all new OIG staff before hiring. Any question about that? Verification of educational and employment background shall be verified, and results of a criminal record search. The results of the background checks may be used solely for the purpose of evaluating the candidates and shall be submitted to the IG. Submitted by whom to the IG?
It'll be submitted by the city administrator's office because the process is they have the contract with the third party.
Okay, the
that's
city
procedure.
Okay.
Mhm.
So the city
So-
administrator's office shall retain an outside person or entity to
Yes.
perform these checks, which shall include. Okay.
Yes.
Any comments on this? I think this is always, of course, standard operating procedures where background checks are concerned. But are there any comments? If not, let's move on to 2.47.060, Authority of Public Ethics Commission. If the OIG does not receive the files and records requested pursuant to Section 604 of the city charter or pursuant to this chapter 2.47 within 15 business days of its request, the Public Ethics Commission shall have the authority to investigate allegations that the head of the offending city department or agency failed to provide the requested files or records to the OIG as required by Section 604 of the city charter or this chapter 2.47. Such requirements shall be subject to enforcement by the city in the same manner as violations of chapter 2.25 of the Oakland Municipal Code. Any comments on that? Hearing none. Section 3, severability. If any section, subsection, sentence, clause, or phrase of this ordinance is for any reason held to be invalid or unconstitutional by decision of any court of competent jurisdiction, such decision shall not affect the validity of the remaining portions of the chapter. The city council hereby declares that it would have passed this ordinance. You moved down and now I lost my place. Okay. Sorry, guys. Any court of competent to the validity of the remaining portion of the chapter. The city council hereby declares that it would have passed this ordinance and each section, subsection, clause, or phrase thereof, irrespective of the fact that one or more other sections, subsection, clauses, or phrases shall be declared invalid or unconstitutional. That's pretty standard severability language. But does anybody have a comment on section 3? Hearing none, can we move on?
I want to say that's the end of the document, and 2.47 chapter chair, but just for due diligence, and prior to you possibly adjourning this ad hoc, can we go up to 2.46? Just because Director Muir had asked earlier about the public ethics language. Yep, right there. Whoop, nope. Sorry, just passed it.
The mediation program?
No, 2.46070.
Authority of the Public Ethics Commission?
If the agency does not receive, I just wanted to make sure it was the same language and he did still have that same authority. There is a note here, and I believe that this might have been Ms. Rashida several meetings ago, that the charter has 10 days and the ordinance has 15 days. And I think that might have been the note. Chief of Staff Montgomery, can you click that, right, that, okay, maybe it was
We
me.
already took note.
Yep, I got it. Just wanted to make sure that was there. Director Muir, is this good? I just want to make sure you were whole, sir.
Thank you. It looks good to me. I do like the severability clause for our section as well, if that's something that's easily copied and pasted in, but I appreciate you flagging that for my attention. And if 10 days makes more sense to just be consistent with the charter, I'm not opposed to that.
Okay, now the
So,
several,
sorry, so there's the note. Should I make the change here too? You think?
no, I'm
Just
sorry.
put the note.
Can we just highlight that section so when Chair
Mhm.
Peterson and other members of the ad hoc has this conversation with
Okay.
other stakeholders, they can discuss, and then it's just easy to flag there for consistency purposes.
Okay, got it.
Question. Since we have a severability clause for both the OIG and CIPRA, should the commission have one as well under their section?
Well, we have to cut and paste the one into the CIPRA one, and you're saying it also should be cut and pasted into the commission.
So
My understanding is that the severability clause, it refers to the entire document.
absolutely,
Uh-huh.
Ms. Rashida,
Okay.
absolutely.
It does, but why is it set forth separately in those two sections then? I
And
agree with you.
It's not. So it's section 3, which is a section in and of itself. Section 2 is 2.47, is the OIG. Section 3 is a separate section. Chief of Staff Montgomery, if you don't
Oh,
mind
yes, okay, I see.
the document. Yes, there.
Okay, thanks. Michelle, I see that it is a separate section. Thank you.
Yes, ma'am. Director Muir, does that help with your concerns as well?
Yes, I'm all set. Thank you.
Thank you. Chair?
So scroll down. Is this the end?
This is the end of the document.
Well, hallelujah and praise God. I guess we've done all the sections now. There, however, were some proactive suggestions that the commission wanted to put in. And Twee, are you on this? recall, because she had the chart, one of which was compensation.
She is, but
She
she's
and
not.
staff may need to elevate her to a panelist.
Okay, give me a second. I have to. I have to go into the Zoom settings to do it. One second, almost there. Tweet, the invite was sent to you just now. Try to oh, can you guys hear me? There we go. Okay. There she is. Okay. Hey, Tweet.
Hi, Twee.
Hi, Chair. Good meeting. So Chair, would you like to queue it up or you want me to?
Well, we had looked at perhaps to the rest of the members of this ad hoc, we had reviewed some of the things that we think as a commission should be added at this time. That, you know, we're doing these edits, we might as well interject our concerns about how the commission is run and how it could be run even better. So we put together a list of certain things that we would like to introduce now, and Twee has that list.
So Chair, as the Chair mentioned, hold on just 1 second, let me camera. As the Chair mentioned, the Commission had requested also for us to take a look at proactively introducing topics for consideration in this revision. I've been collecting throughout the months since the Commission's decision on this last year, a list of it, and I actually had gone and had conversations with the former chair of the ad hoc, Commissioner Shea, around, you know, what to introduce, how to introduce it, et cetera. And the general sentiment, and I also recognize there's a transition here with this ad hoc, but the general sentiment is to provide topically so that to get guidance from this ad hoc as to whether we would like to go in that direction. And then, you know, what are some things to consider? And then I would come back as council with actual language as to what it would look like. So for instance, one of it is a conversation that folks have been having around whether the commission should receive a stipend. And so so let's say, you know, I put forth that topic, and it's not a topic that I'm insisting on. It's what I've been collecting and gathering and hearing. So, and it may not even be of a belief of the commissioners on this ad hoc. So please, I want to make that very clear. It's not a position that anyone has taken on it. It's really just a topic for discussion and whether to proceed in that manner. Another topic that has been brought up is around the role of alternate commissioners. And one commissioner at a commission, alternate commissioner at the time, although she's now a regular commission, had asked whether alternate commissioners could vote for their officers. And, you know, there's some legal barriers around that, but nevertheless, I want to present that because that was asked. But another critical one is whether alternate commissioners can go into closed session. We talked earlier about the IG having authority to review CIPRA disciplinary processes, including the discipline committee. And that has to do, the parameters around that had to do with the Brown Act closed session. Likewise with alternate commissioners, whether there are legal attorney general opinions around that, but I would like to explore with the ad hoc whether it would still want to make certain declarations to enable alternate commissioners to go into meetings. A third example, I'm just giving just to give you all a flavor of just some of the topics, and then I would ask Chair, especially with this transition from the former chair, what process you would like to do. Is another topic of discussion is around, give me just 1 second. I just had it in my mind. Hold on just for a second. Yes, around commissioner appointments. So for instance, we've had on several occasions where commissioner appointments have expired. And so, you know, this notion of maybe having in code the concept of rollover until an appointment to fill the vacancy versus actually removing the commissioner when a term has expired and then creating a vacancy unnecessarily. So it's this notion of maybe building into the code the concept of rollover until replaced, et cetera. So those are just some ideas. There have been several, but I wanted to give you some sense of especially our community members and our commissioner ad hocs on what those topics are. I do, quite frankly, have to do a cleanup of that list because there have been additional items. Quite frankly, it's almost like every month we meet, there's an additional item that the commission goes, Tweet, could you take a look at this? So, and in fact, 2 commission meetings ago, there was also another request by commissioners' leadership. So I wanted to ask you also from a process standpoint, how you would like to proceed. And I can be ready with you know, the topical list so that we can go through it, or just take it piece by piece.
I like the topical list. How would you all like to proceed?
Yeah, I think doing it by topic is a good idea. I also have some concerns about some potential conflicts with the charter language, particularly as it about the terms of the length of the term and the rollover idea, as well as the alternate idea. I want to make sure that we don't insert any language that conflicts with the charter. Thank you.
And that's very important that we don't. So that's why it's good to have all eyes on this particular portion. Certainly, for instance, like stipend, the charter is silent on any form of compensation. And so that wouldn't be a conflict. It would just be something new that the enabling ordinance would allow, even though the charter is silent.
Right, that is a separate thing altogether. But I will say, and I'm not suggesting that you should not make an effort to insert it. But I will say that when we were creating the charter language, this was proposed, having a stipend was proposed. And the city council was quite adamant in refusing it because they said that it would establish a precedent, that we have about 100 other boards and commissions, and that it would be untenable for all of them to receive stipends. So I'm not saying you should try, but I did want to give you the history and to inform you that this was something that we did try to get into the charter language and failed. Thank you.
Correct. And at the beginning, I don't think there was and I'll get to you, Mac, an appreciation of the amount of work that this commission maybe has to do. And maybe now that we know more about the extent and there are new council members, I don't think there's maybe any harm in requesting it again. And I can see the problem. I mean, the Port of Oakland has commissioners, the Public Ethics Commission has commissioners, Park and Rec has commissioners. Where do they draw the line in giving stipends to us, but not the others? I understand. Mac?
Thank you. I will just note, and I appreciate, Rashida, your mentioning that I have heard this concern about precedent noted before. However, I believe the precedent nationally outweighs the local precedent in that nationally, people who serve in this equivalent to a commissioner role are often compensated. The case is true in Berkeley, the case is true in San Francisco, the case is true in many other cities, with an understanding that that shouldn't necessarily set a precedent for every other commission in those respective cities. So while I've heard that rationale here in Oakland, I don't know that it passes muster per se.
Mm-hmm. And, you know, I'm of the opinion too that a closed mouth doesn't get fed. So they pay somebody to tell us no, we're not going to tell ourselves no. So we can ask and they can say no. But I think this may be our time to ask.
And Chair, if I may follow up on that, Ms. Grenache, I think we could really benefit from your envisioning, especially many of the founders and writers of the creation of the police commission, was this notion of preparing the city for civilian oversight when court oversight ends. And there's been real clear indication of how much work court oversight entailed, monetarily, time-wise, et cetera. And that's the commission hasn't even picked up to some extent that level of work, that intensity of work once court monitor ends. So, you know, this notion of stipend could be even within that larger context. So, you know, making an argument for that along with some research that we also did parallel with SIPR Director Meir around what other, you know, neighboring cities along with national cities for commissioner stipend. So, and Chair, so this is the goal, is to have that kind of conversation, right? And then for you to peg what the amount could be. You know, some places have had differences in terms of, you know, the leadership may have a different type of stipend versus the rest of the commissioners, things like that. So then we can get into the detail, but if as we go step by step, we get green light, go next, green light, go next, green light. And I don't want to ever make the assumption that it's something that this ad hoc would recommend to the larger commission. So hence the need for the conversation to say green light, let's put some language proposal, and then green light on the language, then go to the full commission. So if you'd like, Chair, if you'd like to even have have a green light on that right now, we can do that, or we can be more methodical and have the full list.
Well, I don't know that we have the luxury of time, not so necessarily tonight. We will finish out the next 15 minutes and get as far as we can in this topic.
Mhm.
But I don't think we have weeks. And in fact, I implied to Chief of Staff for Councilman Cow and Jenkins that we would complete this work by the end of April. So that would possibly at maximum be 2 more meetings. So if we were to talk about the list tonight, listing topics, green light, red light, would the members of the ad hoc be willing to listen to that and say, yeah, I think that's, yeah, go ahead and do the one on compensation, but don't do the one on whatever else is on the list? How does that sound to the members of this ad hoc?
I think that makes sense.
Okay. Commissioner Jackson, you're the other member of the commission here. Do you have any comments on this and how we should proceed?
Not particularly.
Okay,
I'm just following the conversation.
okay.
So
So,
thank you.
of course. So let's proceed with topics.
All right, so with the first topic, for the stipend, is that a green light to come back with language for review? Or whether it be the next week or the week after, so that you finish by April.
IG Phillips.
So what I will say is that I'm not 100% sure if I'm a part of the ad hoc or not, or if my vote even matters. But given the budget crisis that the city is in, I am not in favor of this right now. Not to say that the commission doesn't do a lot of work, but there, in my understanding and information that we've received, are going to be some severe cuts all the way across the board. So I'm not in favor of this. Of course, I can be outvoted, and that's absolutely fine. But taking into the totality of the fact that I do work for the city and understand that everybody's budget affects everybody else's budget in a way that we just have to be fiscally responsible. So unfortunately, I can't support this.
Well, if we were to couch it in terms of subject to budgetary constraints, the commission should be paid a stipend according to whatever language that follows.
Can you indicate what kind of an amount you're talking about?
You know, we and Mac did a study of this. Mac, do you have those figures? And it's not we're not talking like $1,000 a month or for each one or something like that. We're talking more in terms of enough to cover, say, parking. I've come for meetings and not being reimbursed. I'm only covered for commission meetings, but not any other meetings that I come and park in the garage. I have to pay for myself. I don't know. I have, I laugh and talk about my side hustle. And this isn't just about me, but when I have to do something during the day, or even if I have to go to NACOL or what have you, I don't get paid. So and that could be for other commissioners who also have employment that requires that they take off to do commission work. And you can't necessarily be compensated at the hourly rate that we may be paid on the employment side, but some compensation.
What about
Yeah.
the idea, what about the idea of doing a line item in the commission's budget that would cover those kinds of expenses of the commissioners rather than doing it as a stipend?
That's an approach.
I think it probably would get a more favorable response than a stipend would, because it would not
Open
set
up
a
the gates
precedent.
for others. Mhm.
And given the fact that I believe you don't usually spend all the money that you have each year, and that it would not be a tremendously significant amount of money, that you could establish a kind of expenses line item in your budget.
That's a good idea.
Yeah, that's a good idea, of course. Mac, do you have your hand up on this one?
Yeah, in response to what you mentioned before, I can just read out broadly what the compensation is in other cities. And I have 11 cities here, I believe. So in Berkeley, it's $100 for each board member per meeting, and then $20 per hour for each hour of training they receive, with a maximum of $300 per month for each board member.
Director Mayor, I'm
yeah.
sorry, just to help people follow along with what you're saying. I posted in the chat room the proposed revision that follows the Berkeley model for people to follow along.
Okay, for some reason, I'm gonna pull that up. Right, so this follows the Berkeley model, and just as a general coverall, in Chicago, the police board members receive $1,000 a month. And that's an appellate body that in some ways reflects the commission's work. In the Los Angeles County Sheriff Civilian Oversight Commission receives a $5,000 annual stipend. In Detroit, it's a range of about $4,000 to about $7,000, depending on the commissioner's role. In San Francisco, there are records indicating that it's, I'll say, between $1,000 and $1,500, although there's no statutory language that I was able to find. In Seattle, there's stipend based on a need request. So if you take leave off of work, you can request a stipend, and it's on a case-by-case basis. In Denver, $100 a month. In Boulder, Colorado, $200 a month. And I'm just in Cincinnati, $100 per meeting. I want to just give a general flavor for how this is handled, both locally and nationally. And if I didn't say it already, in Sacramento, the Community Police Review Commission receives $50 per meeting. With the concerns that the IG raised, certainly understood on my part, and I think a line item does make sense, but this is just a general precedent, knowing that these cities aren't necessarily facing the same financial conditions that we are.
IG Phillips.
I appreciate the research that was put into this, and I also appreciate the acknowledgement, Director Muir, of the factors that this city is facing. And I do think, to Ms. Rashida's point, from what I can recall, the last I saw the spreadsheet, I know that the police commission has funds in a miscellaneous pot, and I want to say that it may be $10,000 in there. And I don't know, Director Muir, Chief of Staff, if you have it up, I would gladly go in and pull it up for you all, but that may be the appropriate line item for either for potential reimbursements. If you want to add that, maybe add, a few $1,000, maybe an extra 10,000 or 20,000, or remove from a line item that you all do not use and repurpose those funds, BCR, we call it a budget change request, and move that there. I think that may be helpful. Just
I would agree.
Okay, so that might address.
Chair, if I may,
Yes, of course.
yeah, in the understanding that the reimbursements could be a potential avenue, I will just say, as a resident of Oakland and viewing the city government, anytime that a reimbursement request occurs,
Yeah.
It costs $100 or more in time for people to get that reimbursement through. Each time a commissioner needs to get reimbursed for parking or food or supplies, it does burden the city where it might feel good for the city council to create a line item for reimbursements, but it stresses city government in a way where a $500 stipend might just create a net positive without putting the same burden on the city. That is my personal opinion, looking at the system, with an acknowledgement that the controls over reimbursement may be the better way to go. There's a lot of time and paperwork that goes into even the smallest, a $6 receipt, in a way that I know for me is frustrating.
It took them 6 months to reimburse me for NACO.
So I have my hand raised, Chair Peterson. So I would definitely really have to work with Mac and other resources to figure out how we can do that smoothly. Because if you guys are looking to be reimbursed on a monthly basis, I don't know how consistent that would be in a monthly cadence, if that makes sense, based on what Mac is saying and how we go about that. I guess we would have checks written, or it's a process that we would have to think about. But if it could work, I'm all for it. I just kind of wanted to raise that. It's not as smooth as we'd like for it
It's
to be.
horrific.
Yeah, especially if the point is to get you your money right away.
They won't. I've gone through this process twice with the NACO reimbursement, and even now with the parking fees, trying to get reimbursed, it's taking months.
Right.
Madam Chair?
Yes,
What I'm hearing from Ms. Grenache and others around where the funds would come from, so it doesn't necessarily have to be a line item on reimbursement, but that the funds is actually already coming from the commission budget, right? So it's not asking the city for any additional money for these stipends. And I think that's the sentiment that I was getting from people, which the commission could, as long as there's authority to do so via the revision of the municipal code. So this is essentially, just to lay it out, we talk about that there are no stipends provided. However, the Reimagining Public Safety Task Force report, one of the recommendation was actually to effectuate salaries for the commission to advance racial equity so community members, not just legal experts and subject matter experts, can apply to become members of the commission. So there is some sentiment already, even outside of the commission, around this, and this may also reflect what Ms. Grenache was saying earlier. So I went ahead and put a possible revision of the code that borrows from the Berkeley Municipal Code language, and so you can either accept this proposed revision, reduce the amount, the allocation, increase the amount allocation, or simply reject it. So that would be the vote that I could get from you today, or we just ready everything up for a thumbs up, thumbs down in the next two Monday meetings of April with this commission.
well, why don't we take them one by one? And so we have, what, 2 or 3 more minutes on this call. Is this acceptable? Is thumbs up or thumbs down on this one?
And Chair, would you clarify as to who votes?
Are we getting a consensus of the members of the ad hoc? Mac, do you have your hand up on this?
Yeah, as I think back to a provision in the New York City Charter, you might consider for this creating an exception in situations of financial emergency, that the stipend exists unless, for example, the city council determines there's a financial emergency, which might split the difference. And I can't give you the exact legal language that might apply, but I think that would make this more palatable under the circumstances, is that even if it entered into the municipal code with the understanding that it was immediately frozen, that that might address the issues that are being brought up here.
Thank you so much, Mr. Mayor. Thank you, thank you. That's good. We'll get that.
Emergency.
done. Sorry.
I like all those extra E's. Okay.
My,
Emergency. Okay. Well, of course, I'm going to say that I have a thumbs up on this one. Anyone else have, well, IG, you're still thumbs down, or is it thumbs up for you?
So I honestly don't think it's appropriate for me to vote on this. You all are in effect my bosses. So to vote on my salary is
I
just
mean, as an ad hoc member.
inappropriate. I don't, but I'm only here as an ad hoc member because I'm the IG. So I am going to not vote on this. Thank you.
Okay, I understand.
I will also abstain for the
Abstain.
same reasons.
Well, I guess Ms. Rashida and Kathy, do you have a thumbs up or thumbs down on this?
You know, I think if you build in the emergency clause, it will probably be a little bit more palatable.
Mhm.
But I still think that it would be received better as a line item in the commission's budget. And as Chewy mentioned, if it's in your budget, I don't think it necessarily has to go through the reimbursement process if it's within your own budget.
So we would
And
just submit a request for reimbursement to Mac. I guess he's still our what, the administrative, he does the administrative
Right.
function for the commission. And
right,
so how
So
does
I-
he issue a check to us?
right.
Who
So
issues the check?
I personally, I think that is a more palatable approach, given the circumstances that the city is in and will probably be in for the foreseeable future. I think if you're actually interested in getting hold of that money, you'd be better off incorporating it into your budget and not being subject to the emergency provision, because that way you probably won't ever see it.
Ever see it? Yeah, that's a good point. Commissioner Jackson?
Yes,
Do you have any further comments on what we're trying to achieve here?
I guess I seem a little conflicted. But I don't have any additional comments. I'm just listening to the conversation.
Okay, well, we want to, of course, decide on which version or proposed version we want to have. Maybe we'll have to do some more thinking with Mac and Micah, how to run this through our own budget as opposed to going through the city, because I can quite frankly tell you that it is a horrific process to go through the city. Horrible. So we put a pause on this one, and it is 11:34 my time, 8:34 your time. How many more topics do we have, Twee, do you think that we need to discuss in this ad hoc?
I'm going to try to pare it down some more, but quite frankly, my list right now is about 34 topics.
34 topics.
Yeah. But I'm gonna try to pare it down in light
Okay.
of.
And-
Can I suggest that maybe we get a copy of that before our next ad hoc so that we have time to
Yeah.
give some thought to it before we meet?
Yes.
Yes. Good idea. And that's what we will do. Our next meeting will be on Monday, April, I guess it would be the 22nd.
Mhm.
Yes, same time, same station. So, any further comments tonight, or can we sign off? Okay, everybody have a good evening, what's left of it.
Good night.
Thank you.
Good night.
Thank
Good
you.
night.
Good night.
Good night.